I've been warned by YouTube that it can sometimes decide that it doesn't want to go live. I have to do the sharing after I've gone live so as to not waste my time. And shared. How's everybody doing? I hope everybody is well. As I have done with the previous excerpts, I'm going to go ahead and dive right in. And here we go. As mentioned before, Donald Trump pressured Mike Pence to overturn the 2020 election. It was his last gambit, and it failed. The committee report reads, over the course of the post-election period, as their other plans each failed, the importance of January 6th and the need to pressure Pence increased. These same lawyers concluded that the vice president could help Trump subvert the election on January 6th, but they would need Pence to set aside history and the law to do so. They'd need him to violate the Electoral Count Act of 1887. The president of the Senate is the vice president. And the vice president has no discretion to make judgments on conflicting votes. And there were no conflicting votes. This was a false premise that Donald and his co-conspirators had employed, that they wanted to spin and snag Pence into. On December 13, 2020, Kenneth Chesebro, a pro-Trump lawyer, sent a memo to Giuliani, the president's lead outside counsel, upon the request of Trump counsel official Boris Epshteyn. Chesebro laid out a president of the Senate strategy, arguing that the president of the Senate, and he alone, is charged with making judgments about what to do if there are conflicting votes. Chesebro argued that when the joint session met on January 6th, the president of the Senate should not count Arizona's Electoral College votes for former Vice President Biden, because there are two slates of votes. Of course, there were not two legitimate slates of votes from Arizona. There were the official electors certified by the state and a group of fake electors convened by the Trump campaign. Everything John Eastman said to support the VP as the final arbiter is utter nonsense. The vice president's authority is purely ministerial, and the vice president has no discretion in changing the votes and doing it, let alone doing it without permission. There's no avenue in the Constitution for the vice president to change the votes of the Electoral College. He's just there to count the votes. And Eastman says the main thing here is that Pence should do this without asking for permission, either from a vote of the joint session or from the court. The fact is that the Constitution assigns this power to the vice president as the ultimate arbiter. We should take all our actions with that in mind. At no point, at no place in the Constitution does the Constitution vest the power of being the ultimate arbiter on the vice president. It just doesn't do that. But something that's curious to me is that John Eastman changed his position on the 12th Amendment and the power of the vice president to overrule the free and fair election. And, one of the things that I noticed in the January 6th report is that John Eastman, while he was an active proponent and the architect of the fake elector scheme by giving it the auspice of scholarship, he actually went back and forth and conceded to the shakiness of this argument himself. Something that Kenneth Chesebro didn't do, something that others who were peddling the fake elector plan didn't do. So it makes you wonder where his allegiances lie. And, there's another excerpt here that I will read in a second that really, it really makes me wonder where his allegiances lie. Eastman wrote on October 17th, the 12th Amendment only says that the President of the Senate opens the ballots in joint session and then, in the passive voice, that the votes shall be counted. USC 3 Section 12 says merely that he is the presiding officer. And then it spells out specific procedure, presumptions, and default rules for which slates will be counted. Nowhere does it suggest that the President of the Senate gets to make the determination on his own. Section 15 doesn't either. By the first week of December, Eastman's correspondence with this same individual illustrates that he was open to advocating for the very point he had rejected before the election. That is, that the 12th Amendment confers dispositive authority on the President of the Senate to decide which slate to count. So in October 17, 2020, Eastman himself says that nowhere does it suggest that the President of the Senate gets to make the determination on his own. But then he flips in December, in 2 months, he flips to adopting the same theory that he rejected in October, which makes you wonder what flipped him. You know, they marketed John Eastman as a constitutional scholar, but in my opinion, he's a criminal who manipulated and distorted the Constitution and the laws flowing from it. He actively advocated breaking the procedures set in the Electoral Count Act. And he did so after having advocated against that position 2 months ago. So you have to wonder what changed his mind and who changed his mind. Eastman wrote that in December 23rd, once he flipped, Eastman wrote that the vice president could recuse himself from presiding over the joint session of Congress. In that event, the session would be overseen by the Senate pro tempore, who was Chuck Grassley at the time, and we recall hearing that. Eastman was clearly arguing that Pence or Grassley should violate the Electoral Count Act. When he gets to Arizona, he announces that he has multiple slates of electors, and so is going to defer decision on that until finishing the other states, Eastman wrote. This would be the first break with the procedure set out in the act. This break with procedure that Eastman's memo was openly advocating was, in other words, advocating for the vice president to break the law. So here he is talking in his memo about a break from the law. I don't know how you say that other than breaking the law, you know? And I keep thinking is, how could a constitutional scholar make an assertive argument that is legitimate in October of 2020 and completely flip it on its head, acknowledge that he's flipped it on its head, and still keep going with it? There's a disharmony here, and I hope that the DOJ and Jack Smith really parses through this. They were simultaneously working on both ends to facilitate breaking the law. Together, this is the basic definition of conspiracy, is that they had knowledge that they were breaking the law. They had the meeting of the minds to orchestrate a breaking of the law, sending out memos, getting people to agree on facts, and then going after the person that they're going to coerce into breaking the law, who was going to then cause the constitutional crisis of upending the rule of law and the will of the people. At this point, Eastman continued, Congress would likely follow the process set forth in the Electoral Count Act, and the two houses would break into separate chambers for debate. But Eastman advised we should not allow the Electoral Count Act constraint on debate to control, and the Trump team should demand normal rules, which includes the filibuster. Eastman thought this would create a stalemate, giving the state legislatures more time to weigh in to formally support the alternate state of electors if they had not already done so. As discussed previously in this report, at the time he drafted this memo and throughout the post-election period, Eastman, Giuliani, Trump, and others were simultaneously working to replace certified electors for the former President Biden in certain states. Eastman, Giuliani, and Trump all pressured state legislatures to name their own separate electors or to certify the campaign's fake electors. So while Eastman was formulating the scholarly plan of breaking the law, Giuliani, Eastman, and Trump were actively working to replace the certified electors with fake electors or pressuring state legislators to pick their own separate electors who would have voted for Trump. That is sedition. That is not just defrauding the United States or defrauding the electoral vote count. That is defrauding the electoral vote count with the intention of grabbing power and undoing the will of the American voter. I don't know what else could be more squarely counted as sedition than that. Eastman was bold-faced about his criminal conspiracy to overthrow the will of the people, and he tried to flip the script and argue that his idea was the patriotic one. Eric Hirschman, White House lawyer, wouldn't have it. The report reads, and I said to him, hold on a second. I want to understand what you're saying. You're saying you believe that the vice president, acting as president of the Senate, can be the sole decision maker as to, under your theory, who becomes the next president of the United States. And he said, yes. And this is Eric Hirschman talking. And I said, you're out of your effing mind, right? And that was pretty blunt. I said, you're completely crazy. You're going to turn around and tell 78 plus million people in this country that your theory is this is how you're going to invalidate their votes because you think the election was stolen. I said, they're not going to tolerate that. I said, you're going to cause riots in the streets. And he said words to the effect of, there's been violence in this history of our country to protect the democracy or to protect the republic. So here he is flipping the script. He is flipping the truth to say what I'm doing, which was actually against what I was advocating back in October, is what is patriotic. And doing what the law dictates, however, is not patriotic. That's what Eastman is saying here to Eric Hirschman, and it's confounding on so many levels. Here we have Pence's lawyer. Jacob did extensive research on the historical analysis of both the Electoral Count Act of 1887 and the 12th Amendment of the Constitution. The 12th Amendment contains a single relevant line. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and vote, and the votes shall be counted. Though Jacob concluded that this line was inartfully drafted, it said nothing about resolving disputes over electoral votes. In fact, and this is me saying this, when you say shall in a constitutional provision or in a law, shall is required. It's not may or not could. Shall means must. There is no discretion afforded to the person to whom this power is vested to change it. They shall open the certificates and the votes shall be counted. There's no other leeway there. Jacob concluded that the vice president must adhere to the Electoral Count Act. The ECA had been followed for 130 years, and every single time that there has been any objection to electors, it has been resolved in accordance with the Electoral Count Act procedures, Jacob testified. After reviewing the history and relevant cases, Jacob found that there is no justifiable basis to conclude that the vice president has that kind of authority to affect the outcome of the presidential election. Jacob stated that his review of text, history, and frankly, just common sense all confirmed that the vice president had no such power. I'm glad that they, rested some of their theories on common sense, because Donald Trump and his co-conspirators are completely devoid of common sense. And that's why they fall all over themselves, is because they think that they can swindle the American people, that they can hoodwink the American people and the rule of law by just pushing a theory that is nowhere in precedent, nowhere in law, nowhere in any judicial scholarship, nowhere in any legal scholarship, anywhere. Louis Gohmert actually sued Mike Pence to force him to break the law. This is a special level of stupidity, right? Louis Gohmert, Representative Gohmert, who I don't believe is in Congress anymore, filed suit against Vice President. In the lawsuit, plaintiffs allege that there were competing slates of electors from 5 states. They asked the court to rule that portion of the Electoral Count Act of 1887 was unconstitutional and that the 12th Amendment contains the exclusive dispute resolution mechanisms for determining an objection raised by a member of Congress to the electors submitted by the state. Essentially, Representative Gohmert was asking the court to tell Vice President Pence that he was prohibited from following procedures set forth in the Electoral Count Act. So now we have a member of Congress at the time going to an Article 3 court and telling the Article 3 court that tell the Vice President, who is the President of the Senate, to violate the Electoral Count Act. It's just absurd to the times infinity. The Gohmert plaintiffs asserted that Vice President has the exclusive authority and sole discretion to determine which electoral votes to count. Although the Gohmert suit was premised on the same theory Eastman advocated, Eastman did not agree with the decision to file suit. Eastman argued that the filing of the suit against the Vice President had close to zero chance of succeeding, and there was a very high risk that the court would issue an opinion stating that Pence had no authority to reject Biden's certified ballots. Those who were advocating to press on with the Eastman scheme did not want to bring it before a federal judge because of the high risk that a court's determination that the scheme was illegal would stop the plan to overturn the election dead on its tracks. This is evidence of corrupt state of mind on the part of Eastman. John Eastman knew that the claim that was being put forward by him and his co-conspirators and Donald Trump's allies would not hold up on the merits. So he actually wanted to bypass the Article 3 courts anyway, but because of the disorganization of this conspiracy, because of the lack of common sense, you get to see their plan just cracked open for all of us to see by their very inconsistency. Eastman is warning Gohmert against going to court because Eastman knows a court would throw this case out, and that would create judicial precedent in favor of Biden and the Constitution and the Electoral Count Act. He wants that to remain unadjudicated. He wants that to remain a case of first impression, so he can argue plausibly that this had never happened before and this is unprecedented. Ultimately, the Representative Gohmert's legal gambit failed. The U.S. District Court dismissed the case quickly. The judge's ruling was upheld by the Supreme Court, which rejected Gohmert's appeal without further consideration. So that was a big back step for this fake elector plan is a lawsuit that Gohmert brought. It backfired, and Eastman knew it would backfire. So, the formative corrupt intent for Eastman is much higher than some of the other people, because here he is trying to maneuver something that he knows to be illegal and fit that into a plot that it is an unprecedented case, and so we can legitimately argue about it, and we can throw this out as being legitimate and not like a seditious ploy. He didn't play the game very well. So we're gonna jump here a little bit and go to John McEntee and Jenna Ellis, who chimed in their traffic court arguments as to why Mike Pence can and should break the law and stop the Electoral Count Act. McEntee said in a one-page memo claiming that Vice President had substantial discretion to address issues with the electoral process. Jenna Ellis argued that vice president had the power to delay the counting of certified electoral votes. In the first memo, she advised that Vice President Pence should not open any of those votes from the 6 states that currently have electoral delegates in dispute. There was no dispute. Ellis asserted that this dispute provided sufficient rational and legal basis to question whether the state law and constitution was followed. Ellis proposed a delay of 10 days as the vice president and Congress awaited a response from the state legislatures, which would then need to meet in an emergency electoral session. If any of the state legislatures fails to provide a timely response, no electoral votes can be opened and counted from that slate. Ellis claimed that the vice president would not be exercising discretion or establishing new precedent, but instead simply asking for clarification from a constitutional appointed authority. So Jenna Ellis's approach was more of a slipping the dagger on the side kind of thing, But where she and her traffic court mind failed is that she was proposing a delay of 10 days. And as the seditious conspiracy statute points out, plotting to delay official proceedings of the government of the United States is an element that would be part of the seditious conspiracy statute. And if it were applied to Jenna Ellis, over here, the delay part of it would incriminate her. Is that, she didn't do anything about violence, she didn't advocate any incitement, but she advocated in legal memos, being a lawyer, delay of 10 days of a ministerial counting process over which the vice president has no authority. He has no express or implicit authority to change how the procedures of the counting goes. In the second memo, Ellis addressed Jay Sekulow, an outside attorney who represented Trump during the first impeachment proceeding. Ellis again claimed that the vice president had the power to delay the certification of the vote. Ellis recommended that the vice president should, when he arrived at the first contested state, Arizona, simply stop the count on the basis that the states had not made a final determination of ascertainment of electors. The states would therefore have to act. Except the truth is, when the electoral votes were sent to Congress, they were already signed, and the ascertainment of electors was signed in the legitimate votes. What didn't have the ascertainment was in the fake votes. And, it's the distinction that they're making in open exposes them to liability. And I don't know if Jenna has ever read the seditious conspiracy statute, or if she has common sense or not, but she should have done her due diligence, because now I believe Jack Smith needs to subpoena her. Mike Pence, on the other hand, did the due diligence. Mike Pence and his staff went ahead and met with Greg Jacob, with Mark Short and Matt Morgan to discuss the joint session. The men discussed various points of pressure being applied to the vice president, including Eastman's theories, the Gohmert suit, Ellis's arguments, as well as how the electoral count process should work. They also discussed allegations of irregularities and maladministration of the election, concluding that none of the allegations raised were sufficient to reverse the defeat. Because of Trump's repetition of electoral fraud allegations, Jacob and the vice president's staff conducted their own evaluation of these claims. Jacob asked Morgan to send the campaign's best evidence of election fraud, maladministration, irregularities, and abuses in the system. The vice president's legal staff memorialized the review they conducted of these materials in a memo to Pence, which concluded, Most allegations of substantive voter fraud defined to mean the casting of illegal ballots in violation of prevailing election laws are either relatively small in number or cannot be verified. They were doing their due diligence. And they were busy covering their own asses. They weren't doing anything forceful. They weren't standing up to Donald Trump's lies. They weren't invoking the 25th. They were not clearly stating that he did not have the authority that Donald was claiming he had. He did send out that letter at the very last minute while Donald was inciting the insurrection on the stage on January 6th. But before that, he didn't really do that. I'll read this last excerpt and then I'll leave it at that for today. That second day, January 2nd, Mark Short released a brief statement on behalf of Vice President. Vice President Pence shares the concerns of millions of Americans about voter fraud and irregularities in the last election, the statement read. The Vice President welcomes the efforts of members of the House and Senate to use authority they have under the law to raise objections and bring forward evidence before the Congress and the American people on January 6th. Short testified that the statement was consistent with the Vice President's views that he did not have the power to reject electors. Short issued this statement because of the swirl regarding the question of where Vice President Pence stood. And I'll just add here, this statement was as ambiguous and spineless as it could get. The pertinent part reading, the Vice President welcomes the efforts of members of House and the Senate to use the authority they have to have under the law to raise objections and bring forward evidence before the Congress and the American people on January 6th. This is on January 2nd when he has had all of this information about what is happening in the background. It's not that he wasn't privy to it. But even then, he sent out this resounding message that he welcomes efforts by members of authority, but members of the House and Senate to use their authority under the law to raise objections. I mean, he's towing the line here saying, okay, you need to use the authority under the law to raise objections and bring forward evidence. So he was towing the line. And he was doing, I believe, a great disservice to the American people, to the Constitution, and to the oath of office that he took. By having information about the seditious plans employed by Donald Trump and his co-conspirators, Mike Pence decides to toe the line and do the bare minimum. He was privy to all of this information. He had the back end information. He was on the VVIP backstage list. They were trying to cajole him, for God's sakes. But he decided that he was just going to do the bare minimum and send out this ambiguous memo about the Vice President welcoming members of the House and Senate to use their authority under the law to bring forward objections and evidence before the Congress on January 6th. I believe that is a dereliction of his duty. I believe that I believe in the very least, he needs to testify in front of the the DOJ grand jury. I don't think that he has culpability because nonfeasance isn't malfeasance, and he knew that very well. I don't think that Mike Pence deserves to be in public office ever again. And with that, I'd like to say thank you. And hey, DJ, hey, Derek. Today I'm on schedule. I'm going to end my session here today. And I'll come back again tomorrow. Let's see what you say. Thanks, Deb. I will see you guys later. So if you have not liked or subscribed, please like and subscribe. And it's already been 30 minutes. Time just flies by when you read these things. So, all right, take care.